Bonjour à tout le monde.
Good morning, everyone. I am Miriam Boudraa. I am the manager of the ITUC of the labor migration cluster. I will speak in French, but most speeches will be in English and the facilitation will be in English. Thank you all for being with us for this important webinar on freedom of association and rights of migrant workers. Today we have the pleasure to have different speakers and practitioners from all over the world. This webinar is available in French, English, and Spanish. And for this, you only have to choose in the menu the language you want to listen to. We have envisaged 2 hours of interactive session, and for this, I will ask you to use the chat. In the chat box, you can post your good practices, and all the links will be posted for the reports. But do not hesitate to use the chat box. If you want to ask your questions, use the Q&A session, because we will take questions only during the Q&A session. And in order to facilitate discussions with the speakers, please specify the person you want to ask your question in order to contact directly the speaker. If you have more general questions and for the ILO, please specify that you want to ask these questions to our ILO colleagues. We have different colleagues with us today with different backgrounds, and they will answer your questions directly also for the ILO and through the ILO. So this morning, we will focus on freedom of association, collective bargaining, and how it can be important for the protection of migrant workers, of their rights. We will listen to international speakers and aspects, and in terms of practices from different actors of the working world from different countries. And we will listen to the reflections on how to cope with the challenges in order to have access to the rights of all these migrant workers. I hope that you'll find that these sessions interesting. And now I will switch to English. I will present our first speakers, and I will thank them.
Take the advantage to warmly thanks Ms. Dasgupta Sukti, who is the director of the Work Quality Department of the ILO. She is overseeing different technical branches, 3 branches actually. The first one on gender equality, diversity and inclusion, inclusive labor market and labor relation as well, and working condition. And the last one is the branch on labor migration. Ms. Dasgupta, thank you very much to be with us today. I will also warmly thanks first I would say intervenant, that is Ms. Katerine Landuyt, who is a senior labor migration specialist in labor migration branch. And together, thanks with Kat, we will have an overview of the report that has been launched by the ILO on freedom of association and collective bargaining for migrant workers. Without further ado, Ms. Dasgupta, I give you the floor for the welcoming note and introduction note on behalf of the ILO. Thank you very much, Sukti, to be with us today. The floor is yours.
Thank you, Miriam, and good morning and good afternoon to all of you. And it's my great pleasure to be with you this morning and to be able to welcome you all on behalf of the ILO to this very important discussion. So freedom of association and the effective recognition of the right to collective bargaining are the core mandate of the ILO and critical to the working of the ILO. And they are foundational to social justice, And they are fundamental rights which all member states of the ILO are committed to. They are also enabling rights, which make it possible to promote a range of other rights and other fundamental rights at work and good conditions of work, fair wages, access to social protection, access to labor protection. And they are, in fact, critical to the achievement of decent work. So this year marks the 25th anniversary of two very important international instruments, which recognize the right to freedom of association. So the first one is the Universal Declaration of Human Rights and the Freedom of Association and Protection of Right to Organize Convention, which is Convention number 87 of the ILO. And both of these are central to giving all workers, which includes migrant workers, a voice and representation. Now, migrant workers as a group are those group of workers whose rights and freedom of association and collective bargaining deserve special attention if we are to promote the ILO's mandate of social justice. Migration has always been a feature of societies, and most migration is linked to the search of decent work and better livelihoods. And the ILO estimates there are about 169 million migrant workers worldwide today. And they are present in all types of economies and societies. So migration is indeed a universal phenomenon, and migrant workers make critical contributions to the countries of destination as well as the countries of origin. Yet migrant workers, especially women migrant workers, are often engaged in precarious, temporary, low-paid work and are significantly underrepresented in trade union membership and in trade union structures as well. And international labor standards of the ILO are clear that freedom of association and collective bargaining rights must apply to all workers without distinction whatsoever. So they apply equally to migrant workers as well. But the problem lies in the application in national laws, in policies, and in practices. And to advance in this area, the ILO has developed this global report that Katerine, my colleague, will present to you today. And this was following a discussion at the ILO conference and a decision by the ILO governing body a few years ago. It was in 2017, which called for the ILO to work with constituents on a report which highlighted the key obstacles as well as the good practices on freedom of association and collective bargaining for migrant workers. The report is very clear in articulating the particular challenges that are faced by men and women migrants and clarifies the expectations from international instruments. And it aims at unpacking the generalizations also around freedom of association and collective bargaining violations so that it can really identify the specific types of exclusions and the specific types of restrictions that exist for the enjoyment of these rights for migrant workers. The report also provides advice to surmount the common practical obstacles to the full exercise of freedom of association and collective bargaining rights of migrant workers at the workplaces. Now, building, amongst others, on the results of the ILO survey on perspectives and experiences of trade union federations around the world, the report helps in the identification of the obstacles encountered in promoting fundamental principles and rights at work, including the freedom of association and collective bargaining rights, as well as shares examples of good practices on the same. I hope this report and the discussions that you will have today, we will have today, really lay the ground for a stronger action towards the realization of fundamental freedom of association and collective bargaining rights for migrant workers. And I look forward to the debate from the distinguished panelists from around the world. Thank you so much for being with us today, for your commitment to this very important topic, and for taking this subject forward. Over to you, Miriam. Thank you.
Yes, thank you, Sukti, and thank you, Miriam. I will try to share my screen. So are we okay on this one, or do I
Yes, you just need to switch. We
Okay.
do see your screen and just
This
excellent.
is fine?
Perfect.
All right. So thank you very much, Sukti, for setting the scene and providing a background for this important discussion. And good morning and good afternoon to participants and dear panelists. So with this presentation, as Miriam said, I will try to give you an overview of what were the main findings in the report in terms of the international legal and policy framework without going into too much detail on that. Challenges, obstacles in law and practice. I mean, also there are some examples of good promising practices to promote freedom of association and collective bargaining rights for migrant workers that the report describes. And of course, there are some lessons learned and based on the trade union survey, as Sukti was mentioning, but also secondary literature, research, but also on the basis of principles and set out in international labor standards that are relevant and comments of our supervisory system. There are some steps, suggested steps forward for governments, but also trade unions and also employers. So turning first to the international legal framework and with a bit of a focus more on international labor standards that are particularly relevant. And Sukti, of course, already said that ILO members, by the mere fact that they are a member state, and under the Declaration on Fundamental Principles and Rights of Work, they need to respect, promote, and realize the fundamental principles of right of work, including freedom of association and effective recognition of the right to collective bargaining. So these are principles and rights that all member states of the ILO need to respect. But there are two fundamental conventions that particularly deal with this area, and these are the fundamental conventions number 87 and 98, which Sukti already referred to. And it's important to know that these apply to all workers, including migrant workers, irrespective of their migration status, residency, or nationality. And for example, Convention 87 guarantees the right to establishing and join trade unions, the right to establish and join organizations of their own choosing to all workers and employers without distinction whatsoever and without interference. And Convention 98 guarantees the right of workers and employers to collective bargaining, and it also protects workers from anti-union discrimination and dismissal. That convention also protects workers and employers against any act of interference by each other. So these are two main conventions that we always have to bear in mind. But there are other international labor standards that are relevant for migrant workers and that are also, excuse me, that are relevant for migrant workers and that also underscore the principles of freedom of association and the effective recognition of the right to collective bargaining. And the migrant workers instruments, for example, which are Convention 97 on migration for employment and Convention 143 on migrant workers, specifically refer to these rights. For example, in Convention 97, there is the principle of equality of treatment with respect to migrant workers who are lawfully in the country and nationals, with respect to membership in trade unions and the enjoyment of the benefits of collective bargaining. And under Convention 143, member states that have ratified have the obligation to respect the basic human rights of all migrant workers, regardless of status. And this has been understood, the concept of basic human rights, as covering those fundamental principles and rights at work, including freedom of association and collective bargaining rights. Then, just very briefly, there are a whole set of other standards which relate to particular sectors, such as, for example, domestic work or rural workers or agriculture, that are important and also refer to these principles. And also the General Convention, Convention 111 on employment and discrimination, refers in its recommendation, 111 refers to the importance of these rights for workers. There are, of course, international other international relevant instruments at the level of the United Nations. These are the United Nations human rights instruments. These are the covenants. This is, of course, also the International Convention on the Protection of the Rights to Migrant Workers and their families, but there are also regional instruments. And Sukti already mentioned the importance and the relevance of the Universal Declaration of Human Rights. And all of this, of course, is monitored by an international supervisory systems, whether these are the supervisory bodies of the ILO or the UN Human Rights Treaty bodies. So it's clear, as Sukti already mentioned, we have a clear, coherent, and mutually reinforcing legal framework on freedom of association and collective bargaining rights for migrant workers, regardless of their status, of their nationality, of country of origin, or the sector in which they are employed. But the problem, as Sukti mentioned, lies in the application in national laws and practices. And the Committee on Freedom of Association, the ILO Committee on Freedom of Association, has emphasized on many occasions the importance of guaranteeing the rights of migrant workers, whether they're documented or undocumented, to organize, and the need for governments to take this requirement into account when adopting legislation. But what are some of the legal barriers, of the barriers that migrant workers face in the enjoyment of their migrant workers' rights? And the report identifies these on the basis of research, comments of the supervisory mechanism, but also from the trade union survey. And what we see is that legal barriers are the ones that are most commonly referred to as obstacles, both by trade unions, but also for migrant workers themselves, and based on comments of the supervisory system. So they take the form of restrictions and inclusions. These barriers, and inclusions that can refer to the right to establish or join organizations of their own choosing, for example, on the basis of nationality. And for example, this is the case in countries like Thailand, or we also have Jordan, where there is a restriction on the basis of nationality to form organizations for migrant workers. But there can also be exclusions in terms of holding trade union office or enjoying full participation or being employed by a trade union. There are also restrictions that we see in terms of where migrant workers are excluded from collective bargaining. And for example, in the United States, we see that certain sectors, domestic workers and agricultural sectors, are where many of the migrant workers also work under the H2 temporary labor migration program, are excluded from the application of the National Labor Relations Act, although at state level there are some differences and they are covered. So these restrictions, as I mentioned, can be based on nationality or residence requirement. This is the case, for example, in Kuwait, or when we look at the Central African Republic, we can, for example, see that there is a double restriction based on residency of 2 years and on reciprocity, that the other country where migrant workers come from also have to guarantee freedom of association and collective bargaining rights. Restrictions are there also for undocumented workers, and this is what we see quite often, certain sectors and of course certain types of informal work arrangements. But there are the survey that was undertaken in 2021 also has identified some other obstacles in addition to the legal obstacles, and they can be political, social, cultural, economic, and gender related. And the slide I'm putting up here is showing you that when you look at the legal, that whether you are low income country, middle income, high income country, their legal obstacles are really the ones that are for most of the regions, except for Europe and Central Asia, the obstacle most identified. And so the trade union survey showed that major obstacles that trade union representative perceives are impeding their ability to support migrant workers. So they are the legal restrictions on participation of trade unions, but also migrant reluctance to or any fear of engaging in trade unions. Gender issues have been identified as an important obstacle for women, also because of the basis of gender or cultural norms, that it is not seen as suitable or appropriate for women to engage in organizing. Anti-union political sentiment was also mentioned, and the nature of the work that migrant workers are engaged in. But there are also some of the practical barriers that migrant workers themselves have identified that hamper their ability to organize and join trade unions. And I've put up sort of the main areas in which they are happening. And one of the very important one is actually temporary stay, including in the context of temporary labor migration program for migrant workers. That we often see that the temporary nature of migrant workers stay in a country was really identified by the survey as an obstacle for trade union outreach. And they're known to be the most challenging group of workers to organize. But the work environment was also identified as an important obstacle by workers because, for example, of the specific characteristics in domestic work in terms of isolation, the triangular employment relationship, the dependence on the employer, were also reasons why it is difficult to organize. And of course, language barriers make it difficult for migrant workers also to understand and inform themselves about their rights and get access to justice. It is also, what was also mentioned is that discrimination and anti-migrant attitudes had an impact on migrant workers' willingness to organize. For example, if migrant workers are arbitrarily stopped or detained or reported, they will refrain from taking actions that put them in a situation of the law enforcement, and of course, it interferes with their organizing. I just put up here a slide to show that the report, and you will see the quote in the annex, which is also about the survey of the trade unions, some of voices of the trade unionists that are important. But what we see is that to a very large extent, the perspectives of trade unions and migrant workers dovetail and overlap with regard to the barriers that impede migrant workers to exercise their freedom of association and collective bargaining rights. Now, turning to some of the good practices, and this is important. Where good practices, yes, sorry. We can actually divide them up in more, or in the report divides them up in sort of 7 areas. Of course, good practice is always removing legislative restrictions on forming and joining trade unions and allowing migrant workers to full participate in their activities. And for example, we have recent legislation that has been amended in Algeria to allow trade unions. Same case for Turkey, to allow trade unions also to engage in freedom association and collective bargaining. Countries have also engaged in multilateral and bilateral agreements, and we probably hear later about this from our speakers. But for example, we have bilateral agreements between Canada and Honduras, who specifically refer to the principles of freedom of association and the effective recognition of the right to collective bargaining. Of course, migrant workers forming trade unions, and we will hear again an example this afternoon, is a very important way to ensure migrant workers have freedom of association and collective bargaining rights. And at the global level, we have, for example, also the International Domestic Workers Federation, who has done extensive work on this. But in terms of outreach and linking this to trade unions, of course, trade union-led migrant resource centers have also helped organizing migrant workers and helping them form trade unions. And social dialogue and tripartite committees or collective bargaining is an important way to advance these rights and ensure these rights for migrant workers. And there again, we will hear of important steps have been taken at national level in terms of tripartite committees that have been formed to also inform and design and help implement labor migration policies. And trade unions have of course outreached to migrant workers and have concluded partnerships and networking, including with trade unions abroad. And we find quite a number of cross-border agreements from countries, and again, I think we might hear some further very specific examples on that. And some of the initiatives, some organizations and trade unions have taken initiatives specifically targeting women migrant workers, and this mainly relates to migrant domestic workers. And we can also see this, for example, from the Indonesian migrant workers organization who has done this. So again, the report has a number of quotes from the trade union survey on suggested strategies that are used to support migrant workers, whether this is cross-border negotiation or whether this is outreaching to migrant workers. Finally, getting to the suggested steps forwards, I mean, what can governments do? I mean, and what can trade unions do and employers? Of course, they can do many things, and these are just suggestions on the basis of the information that we had. First of all, of course, governments can ratify and should ratify the fundamental conventions 87 and Convention 98. And leading to that also remove legal obstacles. And we've seen some examples for migrant workers to engage, to organize, form trade unions and engage in collective bargaining. Obstacles related to nationality, residency, or work permits, for example. They can also create an enabling environment through social dialogue and in consultation with social partners for the formation of independent trade unions and migrant workers, and create that environment for collective bargaining, promote social dialogue and tripartite mechanisms, and conclude bilateral labor migration agreements. I think I will almost end. I need 30 seconds, Miriam, just to point to the trade unions, of course, continue to build their capacity to organize, and we will hear examples on that, and adopt strategies on collective bargaining to cover particularly non-unionized sectors, but also undocumented migrant workers. And employers can help with sharing information about the rights of migrant workers and recognize the independent and representative trade unions formed in the workplace and engage in collective bargaining. I'll stop here. Thank you so much for your attention. And I'll turn over to Miriam again. Thank you.
Thank you. Thank you very much, Kat. I think it was very interesting to hear indeed, as you mentioned, in the introduction made by Sukti, but also in your very clear presentation that freedom of association and collective bargaining are fundamental rights, and that all member states, as you mentioned, need to respect, promote, and realize. There are some specific ILO instruments, 87, 98, covering this specific aspect, but we also seen, and you highlighted, Kat, in your presentation, that also some specific instruments more related to migration or domestic work are also highlighting these principles. In your presentation, I think it's very clear that there are still some challenges remaining in the implementation application of these principles, and you provided some examples from different countries. But I think what is important, and this is why we do encourage all the different participants to really dig into the report, and I see my colleagues Elisa, she put the link directly to the version of the report that is available in the 3 languages, that there are still some legal obstacles and practical barriers which limit access to migrant workers to freedom of association and collective bargaining, but there are also some good practices, and you highlighted them very clearly, Kat. You finalized your presentation while also what are the next steps and what can be done by government, trade unions, and employers. And we will indeed hear from the voice of the actors of the World Award in the second part of the webinars. But again, we really encourage the participants to download the report that has been very clearly highlighting the pointed, and to go much more in depth of what you brilliantly presented, Kat. Thank you again for your presentation. I just want indeed, before moving to the first burst of discussion with our expert, to highlight there are already some questions in the Q&A, and some good practices also, and comments made in the chat. For the Q&A, I just would like very much also to insist, please specify if the question is directly addressed to a speaker, and if it's more questions that you want to address to the ILO or colleagues that are joining us today, we try to answer by writing. But let me indeed now try to dig a little bit more the discussion and kindly asking two international experts to join us. And together with these two experts, we will try to discuss a little bit on how can collective bargaining helps better migrant workers' rights. So we have the pleasure today to have with us Ms. Petra Herzfeld-Olsson. I hope I'm pronouncing your name properly. And Ms. Olsson is Professor of Labor Law at the Faculty of Law of Stockholm University. Your field of research is very much related to labor law, European law, and human rights law. And if I'm not mistaken, in your dissertation, you investigated the scope of workers' rights to freedom of association in particularly the EU and the Swedish law, as well as in the UN law. And during the last years, which is quite interesting, your research also focused on questions related to labor migration. And in a specific numbers of research projects, you have seen how the EU regulation on entry and stay for workers from a third country had some impact at the national level. So very much again, Professor Olsson, thank you so much to being with us today and joining from Stockholm. Then I would like also to introduce the second guest, Mr. William Gois. Mr. Gois, he's joining us today from Geneva, but he is known for also being the current regional coordinator of Migrant Forum in Asia, based in Manila in Philippines. MFA is a regional network of grassroots organizations, trade unions, and faith-based groups, migrants and their family, and the individual advocates in Asia, working together for social justice for migrant workers and members of their families. And MFA is representing 26 countries in Asia and in the Middle East. Mr. Gois, over the last 20 years, has been the forefront of international advocacy efforts, engaging and influencing international and multilateral process to promote rights-based migration and policy development. William, to you as well, thank you very much to joining us today. It's a pleasure to have both of you with us during this this webinar. I will maybe start with questions for you, Petra. As a distinguished professor of EU labor law, could you delve into the pivotal role that freedom of association and collective bargaining plays in shaping the landscape of migrant workers' rights, and particularly in the context of the EU? Are there some specific legal mechanisms and landmark cases that exemplify the impact of these principles on safeguarding the rights and interests of migrant workers? And how might this experience resonate at a, I would say, maybe more global scale? The floor is yours, Professor Olsson.
Okay, thank you so much, Miriam, and thank you so much for inviting me to this really extraordinary webinar. It's been so interesting so far, and I really look forward to the discussion. So I will describe how the right to freedom of association and collective bargaining for labor migrants has developed on EU level. You mentioned, Katerine mentioned in the presentation, that legal obstacles is maybe not the most problematic thing within the European Union, but I will try to explain a little bit how it has been dealt with, and also highlight a specific role that a catastrophe actually played in shaping those rights. So in the beginning of 2000, EU started to negotiate new EU laws, directives on labor migration from outside the EU, third country national workers. And important to know is that such directives are binding for the now 27 member states. So the starting point was that the EU needed workers from outside the European Union in order to stay competitive. And the idea with this exercise was to create a level playing field. An important starting point when negotiating this directive was to ensure equal treatment for labor migrants and national workers with regard to working conditions in order to prevent exploitation and social dumping. the third country national workers should not outcompete the national workers because they would be less expensive. That was the argument in the Commission's preparatory work. The negotiations, however, were really, really difficult because the member states were really reluctant to give away sovereignty over their borders as well as over their labor markets. The first directive adopted was a directive for highly qualified labor migrants, the EU Blue Card Directive. And these workers were, in the adopted directive, provided with the right to equal treatment regarding terms of employment and working conditions, but also equal treatment with regard to freedom of association and affiliation and membership of an organization representing workers or employers, including the rights and benefits conferred by such organization. This may be a first good step, but this provision is too vague. What is worrying is that the right to collective bargaining and the right to strike is not mentioned in this directive. And the second directive adopted was Single Permit Directive. It applies to all third country nationals with the right to work in the European Union. Here we find a similar equal treatment provision as in the EU Blue Card Directive. But as we know, having an ambiguous right to freedom of association is, of course, crucial, but without effective enforcement mechanisms, it may be very difficult for labor migrants to exercise these rights. This has also been highlighted in the report. The vulnerabilities created by migration status and information gaps makes it important to ensure these effective enforcement mechanisms. But in these two directives, there are no such mechanisms, which is another clear shortcoming. So the next group the European Union had agreed to regulate was the seasonal workers. But during the negotiations, a catastrophe happened in Greece. Bangladeshi migrants living in Greece without a work permit were recruited to work in the region's biggest strawberry farm at Manolada. The workers had been promised wages for 7 hours work a day and also for overtime compensation. These workers worked every day from 7 to 7, picking strawberries under the supervision of armed guards. But they were not paid and went on strike without success. Shortly after the strike, the employer hired other Bangladeshi workers to work in the fields. The previous 100 workers feared that they would not be paid for the previous season, an approach to employers to demand for their outstanding wages. One of the armed guards opened fire against the workers, seriously injuring 30 of them. Greece was eventually convicted for violating the prohibition against human trafficking in the European Court of Human Rights. But for this particular intervention, this event was a wake-up call for the whole European Union. It made them aware of the horrible situations in the seasonal sectors within Europe. And this had repercussions on the negotiations on the directive on seasonal workers. So the member state, after this event, could not, without losing trustworthy, argue against strong rights for the seasonal workers during the ongoing negotiations. So in the Seasonal Workers Directive, we find a much stronger right to freedom of association, explicitly providing for equal treatment, also with regard to the right to strike in industrial action, into the right to negotiate and conclude collective agreements. This directive is also provided with provisions on monitoring, assessment and inspections provisions, with facilitation of complaints as well of effective sanction, something which is lacking in the other directives. So it is not that also these provisions could be firmer, of course, but step by step, the EU has recognized that a comprehensive right to freedom of association and collective bargaining is crucial also for labor migrants. And now, when the European Union is revising the other directives, the Commission seeks inspiration from the Seasonal Workers Directive. So hopefully, in the second round of directives, there will be a comprehensive recognition of the right to freedom of association and collective bargaining, including an effective right to enforcement mechanisms and access to justice for all labor migrants within the European Union. So thank you. This was only what I wanted to share with you here in the beginning.
Thank you very much, Petra, for your intervention. It's very interesting to hear from your intervention how the working condition of seasonal workers in the EU was a kind of wake-up call, if I might put it in that way, on access as with regard of fundamental rights of migrant workers, with regard of freedom association and collective bargaining. And we see, if you can have a look also in the web, in the chat, there are some participants also saying, well, fishing sector, you know, in my specific case is a little bit the same. So indeed, it's interesting from, I would say, potentially from a sectoral point of view, how it can be indeed more challenging. And as you mentioned in the EU, how that was a way to kind of hopefully put a little bit, you know, go in a step forward for better protection of migrant workers with regard also access to freedom of association and collective bargaining. And you highlighted what is also changing in some of the enforcement mechanism and access to justice. So we thank you very much for that. You stay with us because we still have additional questions for you. And I clearly also encourage participants, any questions to Professor Olsson, please use the Q&A for any question you might have to her. Let me now go also seeing from the perspective of Mr. Gois, so William, who is working, we have seen from the presentation, for more than 2 or 3 decades now on the questions related to protection of migrant workers' rights. So, William, we have seen from the presentation of the report that migrant workers not only face legal obstacles with regard of freedom of association and collective bargaining, but they also have many practical barriers and practical obstacles to enjoy this right in practice. What are some of your experience with regard of this practical obstacle, and in particular for women migrant workers, because we know that also from what Kat mentioned, that it might even be more challenging for women migrant workers. Do you know any strategy in the region you're covering that have led to positive changes? William, the floor is yours.
Thank you, Miriam, and thank you to the ILO for this kind of invitation to be on this panel. And thanks to Kat for bringing out the highlights of the study, which I think are very, very on the spot in terms of the output and recommendations. I'm looking at the chat box as well and to what Petra has just presented. And let me first start by saying I think we have to take into account that at least in our region, and I'm talking about the Asia, Middle Eastern region, but now it seems to be that this model of temporary labor migration program is prevalent throughout the globe, whether it is in the Western Hemisphere or the Southern Hemisphere kind of thing. And I think as the ILO, this really needs to be looked into. And I'll give from our own region, from Asia Pacific region, when countries of origin that are members of the ILO, when they deploy migrant workers on contracts that say they cannot join trade unions, I think this needs to be questioned, because the temporary labor migration program, at least in our region, is set up to prevent freedom of association and collective bargaining for migrant workers. The very fact that you have quotas by nationalities, the very fact that you have differential in wages for the same job among nationalities, all these kind of measures prevent the coming together of workers under the common identity of worker. And I think this is the biggest challenge that migrants kind of have in terms of coming together in freedom of association and joining trade unions. But having said that, I think it is a natural impulse also of migrant workers to join associations and to move towards some kind of organizing principle among themselves. Some of the classic examples that countries are now cashing in on. For example, if you go to Hong Kong on any given Sunday, you will see it's big. The financial district, which is basically closed off on Sunday, becomes a tourist spot, and Hong Kong actually now promotes it as a tourism kind of site to visit, because that whole financial district is now taken up by different associations of migrant workers, Indonesians, Filipinos, Nepali, domestic workers, women who have come together naturally to form associations and groupings that they think give them the kind of support they need, which would be useful for them in understanding the issues that they have and seeking recourse whenever they are in trouble. And it is good that some of our trade unions from the region have recognized this and have worked with this kind of organic principle of organizing among migrant workers. And today you have trade unions from our region that have reached out to some of these women organizations, may become kind of affiliates of them without having to reorganize them, but taking them into partnership, taking them into membership and things like that, and experimented in different ways of connecting and networking with them. And I think this is a classic, fantastic example of how the labor movement kind of organizes itself in order to be able to advance labor rights. I think that is crucial kind of thing. This is one example. If you take in the Middle East, again, you have examples like that. And I must say today, workers are a lot more aware of the need to come together than what we had in the past. And today you do have a lot of self-organized processes among migrant workers and trade unions tapping into that. There's a lot of experimentation happening. The most recent one in Bahrain, where you have now a trade union of domestic workers that has been affiliated very early in our region. In Korea, you had undocumented migrant workers in South Korea being affiliated as a trade union with the major trade union of Korea, KCTU. So you have these kind of examples, but this needs to go further, because the structural barriers that are there, beginning from the contract that is signed, which says you cannot join trade unions, from that kind of barrier, starting from country of origin, right down in country of destination, and Kate has pointed all that out very beautifully in the research. I think we will have to look at how we come back to what is fundamental rights and recognize that this is fundamental rights. We can no longer create this kind of fictitious gap between migrant worker and local or national workers in trade unions. I think this is going to be critical to how we advance freedom of association and collective bargaining in today's world. And even more, because in our region now there is a changing scenario. We had temporary labor migration programs, which were in a certain sense permanent, because even if the contracts were for 2 years, it's a cycle of almost 10 to 15 years of the migrant worker. So there is that kind of possibility of organizing that. But now there's a new phenomenon in our region post-COVID, and that is the seasonal worker program, which is only for something like 2 months, 4 months, 6 months, these kind of during certain harvest times and things like that. It is going to be very important for us for the ILO to pay attention to this and look at what would be the ways of organizing. In our region, some of the trade unions like GFOND and APL, Alliance Centro, and SARTOC in our region have been looking at membership across borders. We've had bilateral agreements between trade unions between the Middle East and Asia, but a lot of this is in its initial kind of stages, and we need to see how to look into this, how to support this, how to strengthen this, and how to have greater kind of networking. And this is where I think our Asia region becomes an example, because where it is not possible for migrants to work in trade unions, there is a very good collaboration between MFA and trade unions in working together on trade union issues. But I think if we don't start looking at collective bargaining and freedom of association within the migrant worker sector, I think we will have huge challenges in looking at the deficit in the decent work agenda and indicators of forced labor. One of the big examples that we have is during COVID, we launched this Justice for Wage Theft campaign, where migrants were deprived of their wages, what was due to them, and end of service benefits. We have to do it case by case. But if migrants were allowed to join and form trade unions, it would be a different story. It would be a different story in relation to forced labor indicators. We would have much less forced labor issues. And I think countries of destinations need to start recognizing this and give that freedom of association to migrant workers, because I think that will be the turning point in at least some of the vulnerabilities that migrant workers face. So I think it's going to be a pivotal issue for us to take forward. Thank you.
Thank you very much, William, for giving us a very comprehensive background, I would say, of what is happening in Asia and Middle East. I think, well, it's good, Olusegun, as you say. You started with also from very positive and I would even say promising practices that we can see in different countries. You highlighted also that through the different years, migrant workers took also conscious of the needs for them, you know, to be associated to trade unions or to organize themselves. You highlighted, for instance, migrant workers, migrant domestic workers that are also creating their own sometimes trade union or affiliating to trade unions. You highlighted also the specific case of undocumented migrant workers in an irregular situation that also are protecting and joining trade unions. You highlighted, in fact, also some of the challenges that remain. And I think in a way to connect it with what Petra mentioned, the challenges related to temporary migrant workers and ensuring, and I would take it from your intervention, that we shouldn't create fictional gaps. And I think this is indeed very important between national and migrant workers, and maybe even more for migrant workers in temporary situation. Again, I think it's important also how you say how there is now what post-COVID, you know, lead with regard of freedom of association and collective bargaining for migrant workers, and we have to keep an eye on that, and particularly with some new programs of migration that are emerging from this post-COVID situation. I will come back to you in a moment, but maybe let me, Petra, ask you, I would say, a follow-up question with regard of your intervention. Well, we have seen that for many migrants, and I think we also see here that from William intervention, for many migrant workers, effective exercising of the rights to collective bargaining is still a challenge. And from your experience, how do freedom of association and collective bargaining contribute to fostering inclusive and equitable working conditions, especially for migrant workers within the EU? So how this could bring to more inclusiveness, I would say, to migrant workers in the EU?
So thank you, Miriam, and thank you also, William, for your extremely interesting intervention. So I will actually give you two examples from my own country, from Sweden. Many of you have probably heard about that Thai farmers has for a very long time come to Sweden during the late summer and early autumn to pick wild berries in the forests. And year after year, it has been reported that these workers have been heavily exploited and have not been given the wage they were promised by the employers. And one of the problems was that there was no trade union that was responsible for this sector at all, as there were no Swedish workers that were active in the sector. So about 10 years ago, a trade union, the municipality trade union, decided to take on this branch and concluded a collective agreement with the employers for the wild berry picking sector. And together with the Foreign Service in Thailand and Sweden, it was decided that the employers were obliged to adhere to this collective agreement during the work permit application process. So this collective agreement actually was the minimum standard that everyone had to recognize even before these workers were given a work permit to come to Sweden to do this work. So this is a very good example on how a trade union is trying to reach out to a group to help setting a reasonable standard of working conditions. But the problem for this trade union is, however, that the workers they've not been interested in becoming a members of the trade union, and therefore it is still very difficult for the trade union to help them when it turns out that they've not been paid the wages they should have been paid in accordance with the collective agreement. And this is also something that I think we have to discuss, how we can encourage labor migrants to join trade unions. And this is very much related to the fear that they will not be welcome back next year if they make noise and complicate things for the employers. But anyway, I think that this is a first important step to have this collective agreement. The other example, if I've got the time, Miriam, is for the Foodora workers in Sweden, the delivery workers. Foodora in Sweden, they actually employ Foodora deliverers who use cars when delivering the different food and other goods. So after very long and complicated negotiations, the Swedish transport worker trade unions succeeded to get a collective agreement with the Foodora with Foodora for those delivery workers who used cars. And the collective agreement is not as extensive as other collective agreements in the sector, but still an extremely important step forward to improve the rights of these workers and ensure that these workers are getting a stable income. And in both of these cases, the trade unions in Sweden decided to act outside their normal structures. Their efforts played an important role, even if in particular with regard to the seasonal workers, additional measures must be taken. But I still think that this is two very important examples of how trade unions can adopt or can enter into negotiations on collective agreements for very vulnerable groups in order to try to help them and go beyond how they normally act in order to set these kind of standards.
Thank you very much, Petra, for sharing this two specific example from Sweden. I think what I understand, it's very interesting to see how, well, basically trade unions started to think out of the box and trying to reach out workers that are not necessarily easy to see, easy to reach out. And while you were presenting, I was obviously automatically thinking about the importance taken also by the gig economy, the platform workers, and how indeed, you know, with this new kind of form of work as well, we need to ensure that no one is left behind, and we do ensure that they do have access to freedom of association and collective bargaining. We know as well that in many of these, particularly in Europe, in many of this kind of new form of work, many migrant workers are working into, for instance, gig economy or platform workers. And I think it's very interesting to see the effort made at the national level by trade unions to reaching out migrant workers, despite the fact that potentially the workplaces might be different than the general of most of the migrant workers. So thank you very much for sharing this experience with us. Again, you would stay with us for a couple of additional minutes with regard to particularly your Q&A. I just want to inform participants after the last question I will ask to William, we will open the floor. I mean, I will take some of the questions from the Q&A to address to Petra and to William. So please don't hesitate if you want them to give you some more information with regard to the intervention. That will be the moment. William, I'm coming back to you, and particularly looking, as I said, to your extensive experience on migrant workers' rights in Asia and Middle East. Can you maybe elaborate on certain of the fundamental labor rights that are particularly crucial for migrant workers in the region you're covering? And how this right, do you think, intersect with the challenges commonly faced by migrant workers in these regions? And how effective protection, because let's maybe come back to indeed what is the heart of the discussion, which is protection of migrant workers' rights. And how do you think this right contribute to fostering fair and dignified working conditions for migrants? The floor is yours, William.
over the years, what we have been able to document of migrant workers' kind of abuse of their rights, it ranges from anything from accommodation to wages to freedom of association to discrimination health issues, access to health, social protection, and all of this. So whatever you see within labor rights or understood as labor rights, there is a definite deficit of all of that within the labor migration programs that we have. And that is something to kind of recognize. And that is because I think, again, like I want to emphasize, because it is on individual contract systems. Because when these contracts and when labor is brought into a country of destination, there is no consultation with the trade unions, for example, that are existing in the country kind of thing. And of course, in the Gulf countries where you don't have in some of them trade unions at all kind of thing, this becomes even more individualized and contractualized. And that is why it is important. It is important that this fundamental right, the freedom of association, is, I think, in a certain sense, the keystone right that will give migrant workers the other rights. Because whether it is decent working conditions or decent living conditions that migrant workers need to be addressed, it is only through the freedom of association that this can happen. In the chat box, you see so many kind of comments. Of course, there is and the report has also brought out fear and intimidation of being deported, employee kind of power dynamics, even the country of origin not being supportive. Even the country of origin not being supportive. Even the issue of migrants, if they complain, immediately they can become undocumented, or as countries of destination say, illegal kind of thing, put in an irregular status, as a result of which they will not be able to continue employment. The fear, the notion, I think, just like how we are saying fundamental rights in labor, the fundamental principles on human rights law, and today we are celebrating 75th year of human rights, which are based on the principles of freedom from fear and freedom from want. Today, migrant workers do not experience freedom from fear. The minute they enter into a country of destination, they have fears. And the fears are from joining trade unions to making complaints on an individual basis. 75 years after this human rights, in the celebration of UDHR, these principles are not yet realized. And I think this is going to be important. The other big thing, of course, is within the labor movement and the trade unions, I think it's time we go back to that slogan of a worker is a worker is a worker everywhere. We are regressing from this notion of the world of work around which the conventions were put up kind of thing. So I think it's going to be very, very important for us to do this kind of, so that trade unions can be involved at the time of deployment in country of origin. But we don't see that kind of as much as that as we would like kind of thing. The migrant resource centers in countries of destination, there has to be a greater collaboration between civil society and migrant and trade unions in this kind of as a common force. This is the labor movement. Civil society together with trade unions is the labor movement. And we've got a lot of history of this in working together and bringing about conventions. We had the Child Workers Convention, we had the Home-Based Workers Convention, we had the Domestic Workers Convention, in which the labor movement came together. Academia, civil society organizations, NGOs, faith-based groups, and trade unions supported each other in bringing about this convention. We need a moment like that today within labor migration governance. I think we need to bring down these kind of, and to see that these rights, and I think the pivotal, the keystone kind of fundamental right will be the freedom of association. Once this is recognized, kind of thing, that migrants have that right to organize, whether it is a self-organized process among themselves to which trade unions tap into, or whether it is their initiative to go and join trade unions and be part of a trade union. I think this freedom is something that needs to have the biggest elasticity in terms of the rights of migrant workers.
Thank you very, very much, William, for your very, I think, strong message and call. And I think you highlighted, and this is something we keep repeating migrant workers is a workers and is a workers everywhere. And I think indeed this is something we very much have to remember. I think in your intervention, what I found very interesting is also you highlighted the needs of collaboration and between the civil society and trade unions, how together they can actually pull their force together and being stronger, because they obviously have a different force. And indeed, as you highlighted, the needs of collaboration and partnership between trade unions and civil society can be key for better protecting migrant workers. And to coming back, indeed, we see some, you witness some step back, with regard of access to fundamental rights to migrant workers. And the one that, as you highly and finished in your intervention, de-emphasize that need to be put on freedom of association, that is key also in a way to ensure access to other rights. So ensuring that by freedom of association, in a way, it's the first step to access also or delocked, if I can say, unlocked certain other rights. Whether then, as you highlighted, say, whether migrant workers want to self-organize themselves or join trade unions, that should be obviously free of them to choose. But indeed, I think from your intervention, we do understand the importance of freedom of association, not as a right, obviously, as such, but as also a meaning to get access to other rights. I think, thank you. I'm looking at the Q&A, and there are some very interesting point, and maybe there is one point that I might want to highlight for maybe for you, Petra, but Vincent, you might also want to look at that specific point. We are, particularly with the specific case of organizing migrant workers in an irregular situation. And if you know certain practices, for instance, that appears in the region, I know, William, you highlighted that as well in your presentation. I don't know, Petra, if you might want, I will maybe give you the floor first to you, Petra, with regard of what we might have seen in Europe, particularly for organizing migrant workers in an irregular situation. I don't know, Petra, if you might want to start.
Yeah. Yes, I could try to say a few words. In Sweden, it has been really difficult, and there are a few trade unions who are actually organizing undocumented workers. We have an independent trade union called the Syndicalists, who have been reaching out to undocumented workers, and they've made a fantastic work in promoting their rights in different ways. So the Syndicalists, which is an independent trade union in Sweden, they have actually been doing a tremendous work, getting into contact with employers when the undocumented workers have not been paid the way they should, also been taking a number of cases to courts, and they're really pushing for the undocumented workers right now. And I saw that you also mentioned in the report that there is a specific center which the traditional trade unions have set up in order to help undocumented workers in different ways. But it is a little bit unclear to me to what extent they help these workers if they are not members of the trade unions that are part of this center. But I'm sure that they're giving them advice, but it's very difficult for them to pursue their rights in other ways. But I know that the situation in other countries are different, but then I only have anecdotal information. I know that in Belgium, for example, exactly as William highlights, that there is collaboration between trade unions and civil rights organizations in order to help undocumented workers. And also in Italy, I know that there are a number of such examples, for example, in the construction sector, where trade unions have done a tremendous work in helping undocumented workers. But that is not anything which I could give you any more information on more exactly how they've been promoting these rights.
Thank you very much, Petra. Maybe can I stay with you for a moment, because we just had an interesting question also from Mr. Francis Solomantin, asking you directly in terms of platform workers in the EU directives. How is the EU directive determines the importance of guarantee the basic rights for workers from the platform economy? Recently, he gave the example that UK's top court ruled that delivery drivers are not classed as workers and cannot form a union. Do you have any comments on this with regard of EU directives?
Yes, so there is an EU directive that is being negotiated right now. The negotiations are they are not finished. We don't really know where it will end up yet. And here the basic points are that these workers should be considered to be workers without having all the different criteria that must be fulfilled in the national contexts normally. And if this will be adopted in the way it was suggested and in the way it looks right now, that will lead to that if they're going to be defined as workers, then they will also get access to freedom of association rights. But the UK is not a member of the European Union any longer, so they will not be covered by this directive in the future, and it's not clear yet what the final content of this directive will be. And there are also different outcomes in different courts in Europe. In Sweden, for example, it has been the development has been the same as in the UK, that most of workers in the gig economy are not considered to be workers, which means that they're not even entitled to occupational health and safety rights. So this is really a difficult situation in Sweden for platform workers. So hopefully this new directive will lead to another and a better outcome for these workers in the future. But still, we don't know what our outcome will be.
Thank you very much, Petra, for your intervention and also information and eye-opening for also what is the situation in the EU. That was very interesting to hear and seeing that it does remain a challenge, but we have I think much more to hear from EU as well in the coming months. Just a question for you, William, because conscious about the time, and we still have some of our participants and practitioners who will be in the second part of the discussion. William, there is a quite interesting questions looking specifically to the case of migrant workers in Jordan, that to what extent they can join trade union, but they cannot necessarily cannot necessarily elected from office bearers. Do you have any comments on what is potentially with regard of association in Jordan? The question was asked directly to you in the Q&A.
Yeah, sure. But let me quickly also just point out to the previous question that Petra responded to, is very quickly, is to say in Korea, Malaysia, and the Gulf, we already have casework where the courts have recognized the rights of undocumented migrant workers, as workers in terms of wages due to them and things like that. So this might be something to look at. I think there is a need, and this is where the platform workers come in as well. There is a need for labor law and human rights law to be looked at together holistically, kind of thing. And I think there's a huge amount of work that could be done in safeguarding workers' rights when we start looking at human rights law and workers' ILO standards together, kind of thing. That might be something to explore. With regard to migrant workers in trade union can join trade unions but can't take up leadership roles. Look, I think it's these are building blocks kind of processes. And I think at some stage, as trade unions gain confidence in taking up migrant worker issues, as migrant workers join trade unions and feel confident that the trade unions are representing them, I think that it will unfold. And these kind of laws will eventually, as we see more and more migrant workers coming into trade unions. But let's take that first step first kind of thing. See how trade unions can be of service to migrant workers, see how migrant workers join trade unions, and see how that becomes a force kind of thing, of collaboration kind of thing in this world of work. So it's not, and in time. And I know that there are some trade unions that are already looking at their laws that say that some roles within as officers of the trade union can be taken up by migrant workers. So it's not as if this is an insurmountable kind of law within the trade unions. I think that we've already had some kind of breakthrough or thinking of breakthrough along those lines. Thank you.
Thank you very much, William, and thank you very much, Patricia, for your insightful income during and discussion during this meeting. Please, you are obviously free to stay with us for this second part, and particularly if you might want to interact also through the chat or the Q&A to participants, you are more than welcome to do so. It was very interesting to listen to you and exchanging with you. Thank you again for joining us during this session. Let me now, I would say, move to the second part, I could say, to this and last part of this webinar. And we have the pleasure to have with us today three representatives of, I would say, the ILO constituents. So we will hear also the voice of our constituents and how ensuring freedom of association, collective bargaining for migrant workers might happen in practice. So I would like in the first time to introduce Mr. David Iigonda. Mr. David Iigonda is Deputy Director at the Ministry of Labour, Industrial Relations and Employment Creation in Namibia. So he will be obviously taking the voice from the perspective of government. We also have the pleasure to have with us today Ms. Carmen Bassan, who is head of unit for international affairs to the Confederation of German Employers Association. And Carmen will obviously be the voice, if I might say, to employers as an employer's representative. And last but not least, we will also have the chance to hear from Ms. Sheila Estrada, who is president of PINACO Workers International in Philippines. And Ms. Sheila Estrada will be presenting from the perspective of the workers. So maybe, David, if I might start with you, if you hear me, and I hope you hear me, and I see you put your mic on, and I see you now as well. David, thank you very much for joining us today. And I would like maybe to if I can hear from the perspective and the context in Namibia as a country destination, a very important and country of destination for migrant workers in the SADC region. How do you perceive the role of employers and workers organizations in contributing to effective labor migration governance? You as, representative of government. Specifically, how do you think social dialogue be leveraged as a mechanism for addressing the unique challenge and opportunity associated with labor migration in Namibia? And how does collective bargaining fit into this framework? Lately, we know that employers and workers had joined to create a network on labor migration. Can you say also the role that this network might play, in particularly with regard of governance in general of labor migration in Namibia? David, thank you again for joining us today, and the floor is yours.
Okay, thank you very much, Miriam, and greetings to you. Yes, in the context of Namibia as a country for destination, we have been hosting migrant workers from different countries within the SADC region.
David, sorry to interrupt you. 2 seconds only. We don't see you very well. I think your camera. Exactly. Nice. Now we can see you. Sorry for interrupting you.
Okay. Sorry for that. Yes. What I'm saying is that Namibia is indeed a destination country within the SADC region, and we have been accommodating labor migrants from SADC region, South Africa, Angola, Botswana, Zambia, and Zimbabwe. And in terms of the governance structure, the governance of labor migration institutions or regulatory framework, we have the Constitution of the Republic of Namibia, which is also making a provision for the freedom of association and also freedom of join and form trade unions and employers organization. And we also have the labor laws that also regulate the also looking to all the workers, including migrant workers, because our labor laws and our laws, they are not discriminative, although they are not really specifically specifying migrant workers, but in terms of the applications, they are not discriminatory. We have Immigration Control Act, we have Employment Service Act, that also make sure that there's ethical recruitment in terms of whether it's local or migrant workers. And again, we also have labor migration policy, which was launched in 2020. This is also to make sure that labor-related issues, which contributing to the development of the country in terms of skills development or investment, it's looking to that, make sure that all it's implemented. So, and this was also developed in collaboration with social partners, the unions and the workers. And in terms of now the role that the employers and workers contributing to the migration governance, they play a big role, as if I've indicated that we have all those regulatory frameworks. Their role is to make sure that all these frameworks have been shared with the migrant workers at all levels of the sectors, whether in the construction or tourism sector. They make sure that all this regulatory framework are really shared with the migrant workers. And again, the other role that they play, and this is also need to be looked at, not only in the case of Namibia, all over the country, that in terms of the development and the implementation of labor migration agreements or migration memorandum of understanding, this also a very crucial part where employers need to be involved to make sure that the bilateral agreements are in line with the conventions and protocols, and also are enforced, or else the memorandum of understanding are also properly implemented. And again, not only the looking into the implementation and monitoring, and not only looking to the development of these agreements or implementation, but also to make sure that these agreements are periodically reviewed in order to identify what are the challenges, what are the issues that can be addressed, and those are the issues that are affecting labor migration, labor or migrant workers. And again, also to make sure that because migrant workers, these are workers, which provide services to the employers. So it's also very crucial for the employers and workers to make sure that these instruments are also mainstreams in the national development initiatives, and also make sure that all these are adhered to. And again, the employers are also very play a crucial role in terms of to make sure that there are targeted programs that are specifically targeting labor migration or migrant workers. And in the case of Namibia, that's although the laws, they are not discriminating, but there are those laws that are not really specifically speaking to the migrant workers, but it's now the roles of the employers, and make sure that they are also in this committee to make sure that wherever decisions are being made, at least it's their participating. And again, another crucial role is that they need to play. These are their workers, and they need to make sure that they are database, or to make sure that there are records of migrant workers. say, for example, with the migrant workers, the term of employment contract came to an end. And now that there's no record, it will be very difficult for that workers to even benefit from the accrued social security benefit that has been contributing. So employers and workers, they really need to, they play a major role in that regard. With regard to the social dialogue and how this can be leveraged, taking into consideration the challenges and the opportunities. Yes, Namibia, like any other countries, with experiencing the same challenge in terms of inadequate social protections, and also in terms of the opportunity. Namibia also benefit from the skills that the migrant workers are contributing to. But social dialogue in this regard is really a key instrument for promoting and achieving decent work for all, including migrant workers, and also inclusive, to make sure that the inclusive development and also social cohesion, because it comprises all form of negotiations, consultation and exchange of information, where the tripartite arrangement, which is government, employers, and workers, are really participating and make sure that the decisions concerning the migrant workers are adhered to or are taken into consideration. Having heard the previous presentation about the fundamental principle around the migrant workers, Namibia also, in terms of the Article 21 of the constitutions, is also make those provisions for the migrant workers to join and form trade unions, and again, and this is also domesticated in the Labor Act of 2007, which also make sure that the migrant workers, which make sure that the employment condition is adhered to all workers, although I have indicated that our laws are not discriminating, but make sure that employment conditions are adhered to, and also all workers, including migrant workers, are benefiting in line of the Labor Act. And again, we also have the Employment Service Act. This is also to ensure that there's ethical recruitment of all workers, also including migrant workers. And again, in terms of collective bargaining or collective agreements, we have sectors that we have collective bargaining in terms of wages and salaries. We have sectors like security sectors, agricultural sectors, and also domestic workers. So the problem in terms of applications, you find migrant workers still facing some challenges in terms of discrimination. You might find also that they are not well represented. They are also not information shared with them. And they are not also associated with unions, so they face those some challenges. But really, the social dialogue is very key, where government have to play a major role to make sure that workers, unions are well consulted in terms of decision making, and again also for the employers and workers representatives also to make sure that they work together to negotiate and also implement collective bargaining agreements that address the labor issues and also other concerns that including migrant workers, in order to ensure the decent work for all, including the migrant workers. Finally, with regard to the last question on the network which was established, as I've indicated that we have developed a labor migration policy, and in order to make sure that this is fully implemented, we make sure that employers and trade unions they are capacitated to make sure that they fully understand the provision in the labor migration and policy. And in August, not in August, but in September this year, 2023, we had a workshop where we capacitate the employers and the workers to understand the provision of the labor migration policy. And with this understanding, there were quite a range of topics and discussions that were discussed in terms of the right of migrant workers, bilateral agreements, and also the type of information that need to be shared to the migrant workers. So as a result of this workshop and the understanding of workers and employers in terms of the benefit and the challenges that that migrant workers are facing, they agreed together to establish a network, and this network is not only strictly for employers and unions, but also open to civil societies and all those that have interest in terms of the labor mobility. And the rationale or the role and responsibility of this network is to make sure that the partners are working together in promoting and protection of the rights of migrant workers, and also not only the migrant worker alone, but also their families, whether it's nationally or regionally, and also globally, and also to make sure that they establish a resource center so that migrant workers are well informed in terms of the role and regulation of this country, and also assist them. And also the other crucial role is also to make sure that the protocols, whether conventions or SADC protocols or AU protocols are ratified, because without these protocols are ratified, without country ratify this protocol, it's also very difficult to fully enforce the bilateral agreements. How will you enforce bilateral agreements for the country which also not to ratify some of the protocols? So the workers have agreed to say that, okay, one of their roles and responsibilities to also to make sure that these instruments are ratified, and also they also
David,
look into, okay, this is now the final one.
I need you to wrap up. It's very interesting, but I also want to ensure that we have time for the other panelists. Okay. But please, I'm kindly asking you to wrap up.
Okay, I wrap up. And one of the responsibilities also to make sure that not only to address the issue at hand, but also to look at what are the push and pull factors of migrant workers. Because if we are not looking into that, we end up just doing damage control, but they would want to also look at those push and pull factors. And they have also developed their advocacy plan to make sure that all these are fully implemented. So with those few, I think I've wrapped up with.
Thank you very much, David, for your intervention. I think we understand from your perspective as a government how you see the role of workers and employers. Very challenging, particularly the role of social dialogue in general in the governance of migration. You have highlighted area for intervention or area where migrant workers and employers can have a very crucial role. I would just, for instance, mention one. You highlighted the role that can be played with regard of MOU and bilateral labor migration agreement in the development, but you highlighted very much in the implementation and monitoring with regard of this agreement. So I think we hear very well from your perspective of the voice of social partners is key, and indeed as well having a tripartite approach to the governance of migration is key for effective implementation of the legislation also, but protection of migrant workers' rights. We will come back to you, David, in a moment in the Q&A session, but I would like maybe, if you don't mind, give the floor to Carmen. Carmen, I think we hear very much, from our representative of government, what is the strong role that could be played by workers and employers representative? And you, as a representative of employer organization from Germany, I would like maybe to ask you, how do you see the effective recognition of the rights to collective bargaining? We know it's not only a fundamental principle, but it's also contribute to the inclusive and sustainable development. And from your perspective, you know, particularly from employers' organization, how do you see, you know, and from employers' organization standpoint, how do you view the role of collective bargaining in ensuring fair and equitable treatment for migrant workers, and maybe giving the example from Germany, because we know that Germany has a significant numbers of migrant workers contributing to its economy. The floor is yours, Carmen.
Yes, thank you, Miriam. Thank you for inviting me and for giving me the opportunity to present our perspective. So the freedom of association and the right to collective bargaining is protected by the German Constitution. In Article 9, paragraph 3 of the Constitution, is stated that the right to form associations to save and improve working and economic conditions shall be guaranteed to every individual and to every occupation and profession. The collective bargaining system in Germany is governed by 3 principles: the freedom to form a coalition. Everyone can form an association, and associations are set up on a voluntary basis. The freedom to join a coalition. No one can force an employee in a trade union or an enterprise in an employer's organization. And the free collective bargaining. Employers and trade unions negotiate wages and working conditions independent of the government and establish them in collective agreements. The minimum working conditions and the minimum wage are set by law. So these are minimum standards for collective agreements. So the freedom of association and collective bargaining autonomy are the pillar of the social partnership in Germany, which is the cornerstone of the German social market economy. As an employers organization, we promote collective bargaining, inform and support our members in all matters relating to labor law and collective bargaining policy, since the central prerequisites for a successful social partnership are strong employers association and trade unions that are willing to engage in dialogue and to find compromise, always keeping an eye on reconciliation of interest of society as a whole. Migrant workers are comprehensively protected in their rights at work under German law. The equal treatment of foreign workers with German workers is enshrined in constitutional law also. The General Equal Treatment Act also regulates protection against discrimination on racial grounds or on the ground of ethnic origin by private actors. So, just a second. The entire application process, starting with the job application, must be non-discriminatory. In existing employment relationship, employees are entitled to protection against discrimination. They can claim damages or compensation and complain to employers about discrimination. To this end, an appropriate complaints office must be set up in all companies, and all employees must be informed of its existence. Another instrument is to protect migrant workers is set up in a Immigration Act, because the Federal Employment Agency is obliged by law to carry out the labor market assessment if foreign workers are to be employed. As a rule, the labor market assessment consists of checking the condition of employment, and this covers the essential working condition, in particular remuneration and working hours. And if the employer is bound by a collective agreement, the collective agreed working and wage conditions provide the basis for the assessment. So all provisions of German labor law are linked to the existence of an employment relationship and not to the nationality of the worker. Accordingly, the collective agreements do not differentiate between domestic worker and migrant worker. This means that migrant workers are free to join and engage in trade unions and to benefit accordingly from the collective labor agreements. But independent of the legal regulations, employers are committed to ensuring a fair treatment of migrant workers in the company in a variety of ways, as employers play a key role in the integration and inclusion of foreign workers in the society. And we have in Germany a skilled labor shortage, you know. So collective bargaining is a key labor human right and a potential enabler of inclusive labor markets. However, this is not the only instrument to ensure fair treatment of migrant workers. It is more a balanced interplay between legal measures and an actively practiced social dialogue. In Germany, the social dialogue is well established and the industrial relations institutions are strong due to a climate of mutual trust and understanding. So I would like to give just a few examples to see what I mean. So a welcoming culture is a part of a corporate strategy in the businesses in Germany. Many companies have set up mentoring programs to help migrant workers to integrate into the company. Permanent contact persons have been appointed to support migrant workers and also to help them find accommodation or schools for children or deal with different administrative problems. Another example is the introduction of a quality seal for the private sector recruitment of nursing professional, which set out binding requirements for fair recruitment, from comprehensive information on labor migration and the future workplace to compliance with international applicable standards and the employer pays principle. Our member organization in the care sector and in the sector of temporary employment agency work are participating in this initiative and have drawn up quality standards as part of a code of conduct that is binding for its member companies. Another example concerns employers in the agricultural sector. I would like to mention the commitment of the employers organization from this sector within the framework of the social insurance for agriculture, which provides operating instructions and health and safety regulation in various required languages. Our member organization in this sector developed also a web app for seasonal workers, which provides information about their rights and about the topic of safe and healthy working condition in various required languages. As an umbrella organization, the BDA is involved also in a tripartite federal Länder working group against labor exploitation and is currently participating in the development of a national action plan against labor exploitation and forced labor, with the aim to enhance the existing measures and instruments and to bundle them better in practice. So I would like I wanted to give these best practices in order to show that employers organizations are also engaged in this area and to ensure that our members are willing to be compliant and to ensure this the exercise of these fundamental rights at work in Germany.
Thank you very much, Carmen, for your for sharing the the case of Germany and highlighting indeed some very good practices on how employers are, particularly through certain measures, trying to facilitate inclusion at the workplace. You mentioning monitoring programs, welcoming programs, and contact, for helping migrant workers in their establishment in Germany, and also the role that they have played, particularly through tripartite structure for eradicate forced labor and addressing forced labor. And we see that from BDA is very much involved into the process. So we see indeed as well how this is important for employers organization, because as you highlighted as well, it's in a way, if I can say, good for business as well, and that is indeed important to highlight it. Let me move to our next and last speakers, Sheila Estrada. Sheila, you will have a very complicated role because you are the last speakers, and we are, I would say, 15 minutes before the end of our meeting. So, Sheila, you are the president of PNA, who established itself as a space for organizing the collective strengths of care workers in the Philippines and in many destination countries of migrant workers from Philippines. Could you elaborate on why it is necessary to establish a transnational labor union of migrant Filipino care and domestic workers? What are the specific initiative or strategy you or your organization are undertaking to actively promote freedom of association for migrant workers abroad? Sheila, thank you so much to be with us today, and you have the floor.
Thank you so much, Sister Miriam. And thank you, ILO, for inviting us here to be a part of the roundtable discussion. Pinay Care Workers Transnational is the first and only transnational union of migrants and local Filipino domestic and care workers. Pinay represents thousands of workers both in the Philippines and in the destination countries in Asia and in the Middle East. As migrant domestic workers, many members of Pinay do not yet enjoy even the most fundamental labor rights in the respective countries of destination. Many, for example, are not recognized as workers and therefore fall beyond the scope of local labor laws. As part of informal economies, our organizations do not reflect the traditional relationships with employers and governments as formal trade unions. Nevertheless, we still strive to secure freedom of association and collective bargaining and other basic labor rights for our affiliates and Filipino migrant domestic workers in general, and also the individual caretakers. Pinay founding in 2022, that was only last year, was 17 years in the making. It's not that easy. There's a lot of challenge. This is the result of the organizing and education work of migrant domestic workers unions in the country of destination and in the country of origin. Its formation and principles are our collective action towards safeguarding Filipino migrant domestic workers' rights, among other objectives. Unfortunately, all the barriers to migrant workers, especially on freedom of association and collective bargaining rights, and barriers that hamper their ability to organize and join trade unions identified by the ILO study are experienced by Pinay affiliates. But our work remains as without FACB, non-protection would simply continue. To that end, mainstay strategies include organizing and education work. We know that the stronger local unions are in the destination country, the greater capacity to represent the workers' interests through campaigns, lobbying, and participation in social dialogue. Instruments like ILO Convention 189 and other conventions are helpful on our campaigns. The extent of unionization and subsequent representation in social dialogue mechanisms varies greatly between destination countries. Where freedom of association is secure, there is far less risk involved in organizing and education work, and fellow migrants can be reached more easily. Migrant workers are likewise more open to joining organization and ultimately gain a deeper understanding of their rights, both the fundamentals and those in the respective labor codes of country of destination. And we can less or avoid abuse and exploitation. A key example for Pinay is one of our affiliate union in Hong Kong. Through decades of organizing, the freedom of association for migrants was achieved, along with annual consultations with the Department of Labor on all prevailing issues such as wages, food allowances, accommodation, malpractices of employers and recruitment agencies, and other issues that affect migrant workers was discussed. Dialogue with the Legislative Council was also happened, and some of the migrant workers' trade unions' victories, I think it's worth mentioning, like what we have done in Hong Kong when we conducted an independent study and campaign lead to a review to the existing law for the recruitment agencies, and it also publicized by the government and study the existing laws. And that comes with a code of practice for employment agencies. And even though there's a penalty of 50,000, this was being increased to 350,000 as we recommended, and included provisions for up to 3 years imprisonment for the same. Second, after a negligible number of deaths and injuries of domestic workers due to falls from high-rise buildings was noticed, unions were lobby able to protect migrant workers in falling from high-rise buildings. And in 2016, a provision in the standard employment contract was added that prohibited employers from ordering workers to clean exposed windows above the ground floor. While there are victories, hindrances to the protection of migrant domestic workers are rampant. In countries where freedom of association is not ensured, even the formation and growth of organizations are victories. Where possible, our affiliates collaborate with our country government, with CSOs, NGOs, trade unions, migrants, and local organizations in the country of destination, and attend some protection and headway for the campaigns. The role, therefore, of the sending country cannot be understated. Reciprocated effort on the side of government is necessary for campaigns to move forward. The Philippines, in particular, has ratified C-189. It must continually be forced to enforce the convention, not just within its territories, but extend its protection to migrating citizens through bilateral agreements. Destination countries, on the other hand, must also realize its responsibility to protect migrant workers as they accept and open their country where migrant workers to work on. It is politically critical for domestic workers to be recognized as workers by the states they are in, so that this acknowledgement may also be normalized with employers themselves. Workers must likewise work towards awareness raising among themselves, again, to lend to further organizing and developing collective power. The establishment of PNAI was the natural next step after the formation of local organizations. Through it, common concerns of Filipino migrant domestic workers can be engaged. Opportunities for social dialogue at various and heightened levels is open. Its affiliate also gain from the experiences and strategies shared by their colleagues and can rely on the solidarity for campaigns. All this for the protection of domestic workers in the meantime, until freedom of association and the right to collective bargaining is secured. We are aware, PNAI is very much aware, that there's a lot of work to do, but we are still having a lot of appreciation what is going on around now, because we find there's a few moves from the governments, from the employers, also to give protection, especially on ILO and UN conventions like this that is happening now. PNAI is very much willing to share and extend the experience and good practices on organizing migrant domestic workers to other nationals as well. For us, for all the workers to be protected, and no workers is unprotected. And we believe that everyone needs to be protected as human beings, as workers. Thank you very much.
Thank you very much, Sheila, for your intervention. It's indeed very interesting to hear from the very practical experience from PNAI, and we know how indeed it's see how you tackle this, in fact, organization, this cross-cutting, I would say, organization of workers. Looking at the time, I see that we have clearly 5 minutes before closing. I know that they might have some question as well for panelists in the chat. I will also encourage you to have a look to the questions that remain, but I would like very much, and if you might see in the webinar chat, there are many congratulations to you, Sheila, Carmen, but also to you, David, with regard of your intervention. I think it was also very interesting for participants to hear basically from perspective from Africa, Europe, and Asia. But obviously, before with regard of the time, I would maybe give the floor to my colleague Victor Hugo Rico, who will very quietly try to close. You have a very big challenge, Victor Hugo, because you will have in a way to giving some closing remarks of this very fruitful discussion we had and comments that were in the chat. Let me just very quickly, Victor Hugo, introduce you to the participants. So Mr. Victor Hugo Rico, he is a senior specialist in workers' activity at the ILO Bureau for Workers' Activity in Geneva, ACTRAV. And Victor Hugo, you will provide some closing remarks in Spanish. And I will then later on officially close the webinars, but for the time being, Victor Hugo, you have the floor.
Muchísimas gracias, Miriam Boudraa.
So thank you very much, Miriam, and good afternoon, good morning to all of you. It is a true pleasure to be able to share some ideas with you. We would need definitely more time to make a decent recap of everything that has been said today. However, representing the director of the ACTRAV Bureau, Maria Andre, that cannot be here today, I would like to thank all the participants and all the people who answered the questionnaire that were basically the basis for all of this report when we talk about the protection of FACB rights for migrant workers. So, of course, let me recap. First of all, we are aware that freedom of association or and also to the benefit of collective bargaining are fundamental rights for workers and employers as well. And of course, the report is on migrant workers, basically, but this is a right that also involves both the social interlocutors. And we've seen so many barriers in order for all of these rights to come to real life. We have legal barriers, we have all sorts of physical barriers, we have problems with the creation of unions, etc. And also there are other things that have to be borne in mind that are linked to languages, in comprehension of contracts, and the impossibility of integrating these people in other realities. A third idea is talking on the contribution that the work that these migrant workers are doing and how the economy is benefiting from their labor is linked to the fact that they have to be respected. So the impact has to be considered and has to be reflected in the protection of the rights of these migrant workers. Reference has been made to the role of trade unions, representing them, promoting their rights, helping them to understand their situation, and also the strategy in order to be able to ensure the real application of all of these rights in the legislation. So we have so many good practices that have been described, and but I would also like to add that we need to give visibility to the migrant worker. of both sexes. And so we need to have a cooperation between the trade unions of the country of origin and the trade union of the country of final destination. So we need to have this cooperation in order to protect the worker, and also to inform the migrant worker on what their rights are. And once again, giving visibility to protection of migrants is important. And also the establishment of centers for resource centers for migrant workers. Now, these centers, they don't just want to look for the migrant worker in the country of final destination, but also they want to make sure that this worker will benefit from the protection of his or her FACB rights. And also the advisor role. We need a program for migrant workers to be able to voice their opinions, especially if they have been part of migration, international migration processes through private recruitment agencies. What has been their experience throughout this experience? What has worked well, which have been the problems, and also access to justice in the country of final destination. So this migrant resource advisor is a very important idea. And I would like to conclude on the importance of the social dialogue. This is the only vehicle that can include, whether it's tripartite or bipartite, the extension of the coverage of all of these rights to all of these workers, regardless of the migratory status. They need to be internationally acknowledged, and also we need control organs, we need jurisprudence in order to make sure that all of these relevant conventions have to be implemented, when ratified, be implemented in the national legislation. So we need to understand the needs, the voids and the vacuums we have, and we have to try to eliminate all of these issues so that the life of these migrant workers will see the enjoyment of their FACB rights. So thank you to all of you who have participated, and I give you back the floor, Miriam.
Últimas palabras de esto online webinar. I will maybe switch to French. So I started in French. I will then finish in French. Je vais donc finir en français et
I will finish in French. Thank you, Victor Hugo, and thank you all speakers, all our panelists, Petra, William. I would like to thank our social partners and representatives of the government today, the Katerine, Sheila, for their time. Thank you all the colleagues. They tried to answer in the chat box the maximum number of questions asked. Thank you, Victor, Melanie, Katia, Miguel. They made their best to ask questions. We will try to answer the questions that didn't get an answer. And I take the opportunity to thank all the participants for their interventions in the chat box, presenting good practices, sharing experiences. We can see from all the comments in the chat box that the feedback was really good, and so the speeches were enriching. And we have participants from everywhere, so I would like to thank the Turin team behind the organization of this webinar, Akim and Marion. And I would like to thank our interpreters, because otherwise our communication wouldn't have been possible. So our webinar is recorded in three languages, you will receive a message. And if you want, you can see again this webinar. It was recorded and it will be published by tomorrow, but you will receive an email with the link if you want. If you want to see again the webinar and share it. So thank you all. It is 12:06. We are 6 minutes late only. So thank you all panelists.